First off, welcome and thank you all for joining us on this webinar today. My name is Kristen Shuck and I am the business manager of the JAMS Boston office. We have a really great program for you today with a very impressive panel. Before I introduce them to you, I'd like to quickly go over some housekeeping items and the goal of our program. Please note that today we're using the Zoom webinar platform, so this is slightly different than the Zoom video conferencing platform that you would use if you were doing a mediation. So while the idea is the same, the look, feel, and capabilities are slightly different. If you do schedule a mediation with JAMS, we absolutely will do demos and whatever trainings are needed prior to any mediation or arbitration. Our program today is called Keeping It Moving, and what we want to focus on is the ways in which you can successfully mediate your case using video conferencing. We'll discuss the benefits and successful methods to video conferencing. We'll also then discuss training, security, and some tips and tricks for making a virtual conference as successful as possible. We'll leave room at the end for questions, so feel free to post any questions you have using the Q&A function at the bottom of your screen or sending me a private chat, and we'll be happy to get as many questions answered as we can at the end. One item I'd like to note before we get into the bulk of our presentation is that while video conferencing may be new to many of you, it's not new to us here at JAMS. While without a doubt, COVID-19 has forced us to use video conferencing on a much greater scale than ever before, we've been doing video enhanced mediations and arbitrations for over a decade. We've invested in the technology to make video conferencing an accessible and easy addition to any of your sessions. If you've ever visited a JAMS office, or hopefully will in the future once this is over, you'll note that we have rooms in pretty much every office nationwide, including Boston, that are outfitted with Zoom-based equipment where a video conference can be started with just the touch of a button. We've understood the growing need for technology in mediation and arbitration for quite some time, which is one of the reasons we were able to successfully transition our business to remote work and virtual hearings in just a matter of days, actually. We have a dedicated staff fully trained to moderate and administer these cases so that you can feel confident with the technology you're using on the day of a session. We'll get into that more in the program, so without further ado, I'd like to introduce you to our panel today. Going in alphabetical order, we first have Siobhan Applewhite. Siobhan is the Manager of Facilities and Administration for the East Central region, and her main role in today's presentation is that she's been responsible for scheduling all of our Zoom sessions and for creating and managing the moderator program. Up next, we have Rich Burke. Rich is the Executive Director of the JAMS Institute. The JAMS Institute is responsible for training and the continued education of all JAMS neutrals. Up next is Deirdre Gallagher. Deirdre is the Associate Director of the JAMS Institute and also a JAMS panelist based out of DC. As you can imagine, Rich and Deirdre have also been quite busy the past few weeks, making sure that our neutrals are proficient in all things video conferencing. Next, we have Judge Nancy Holtz. Judge Holtz is currently on our Dallas panel, formerly our Boston panel, taking cases nationwide via video conferencing. She joined JAMS in 2014 and has since served as a mediator, arbitrator, special master for a variety of disputes involving business commercial cases, civil rights, construction, employment, energy, entertainment, sports, intellectual property, personal injury, and professional liability. Next up is Judge Stephen Neal. Judge Neal is a JAMS neutral out of our Boston office. Joined JAMS in 2011, where he since served as a mediator, arbitrator, and special master in a variety of complex matters involving business commercial matters, class actions, construction, employment, insurance, professional liability, and securities. Last but not least, we have Judge Jim Ryan. Judge Ryan is a JAMS neutral and one of the original members of our Boston panel, joining JAMS in 1992. Judge Ryan has resolved thousands of cases involving a variety of issues, including labor and employment, construction, personal injury, toxic tort, professional liability, products liability, workers' comp, commercial, franchise, insurance, and real estate matters. So now that you've met our panel, we'll get into the bulk of our program. We're going to start with benefits and successful ways of using video conferencing to settle your mediation. First, I'd like to hear from Judge Ryan regarding the importance of preparation for a successful mediation.
Thank you, Kristen. I guess I wanted to start by saying I think preparation is essential to success in any mediation, and it's even more essential in the context of video conference mediation. And that's especially true in this time when many attorneys and their clients are experiencing this technology for the first time. The COVID crisis has really made us all enter into a very steep learning curve. So whenever the parties agree to conduct a video conference mediation with me as the mediator, I always recommend to the attorneys that we conduct what we call a test video conference session in advance of the actual mediation. Each time that JAMS schedules a video conference mediation, it assigns a specially trained support staff person to act as moderator, to provide the technological expertise that someone like myself or of my generation may not share to the same degree. And so I work with the moderator to arrange and conduct the test session. And now, in my view, the importance of the test session cannot be overstated. I recently did a video conference mediation where there were parties from 6 different states involved at the same time. Now, you don't want to find out at the start of the mediation that you're having a problem with someone connecting or participating smoothly. So it's really important to identify any potential problems and get them solved before the day of the mediation. The test session usually takes, in my experience, around 30 minutes to an hour. And I always ask the attorneys to invite their clients to participate as well, because they'll most often be connecting separately. We want to make sure their equipment works as well as the attorneys. I had a recent mediation which an attorney had one client located in California, and the other client was in Vermont, and the attorney was in Boston. And it was really important to that attorney and the clients that they had confidence that they would be able to see one another and speak with one another throughout the mediation process. So by virtue of a successful test mediation session, they were able to start the actual mediation with confidence that the process was going to work for them, and that made them much more comfortable and much more productive in the dialogue. Now, we always try and schedule the test session several days in advance of the actual mediation, and that's to give us time to solve the problem if something arises. I recently did a mediation in which, when we attempted during the test session to send the defense attorney to the breakout session, his screen froze and we couldn't get back in touch with him. Now, if that happened in the actual mediation, it would be very distracting. It would really set us back. So because we identified that problem in the test session, the JAMS moderator was able to work with counsel between the test session and the actual mediation, solve the problem, and everything went smoothly on the day of the mediation. Now, I have an agenda which I seek to address with the parties in each test session, and it really falls into 3 categories: technology, ground rules, and substantive preparation. And let me give you a couple of examples of each category of the types of things that I would address with the parties. Now, unless the parties select a different platform, JAMS generally uses the Zoom conference facility for our mediations. And many parties or their clients, many attorneys and many clients aren't that familiar or haven't used Zoom before. So if that's the case, we'll spend some time making sure everyone's comfortable with the controls, how to mute, how to stop the video, how to chat, how to ask for help, etc. So that would be one thing we'd address if necessary. We also make sure that we have designated a point person for each breakout session or each party, and we have the cell phone information for that person so that we can communicate by text or by cell phone if we need to during the mediation process, or so we have a backup plan if there's a technical problem that we can't solve quickly. We also send the parties to the breakout sessions during the test session so that they experience what it feels like. First time I did it, it was sort of like being in Oz. Suddenly you transform from one space to another. And so to give people an advanced experience of that, I think is a helpful thing to do. Next, on ground rules, I'll give you a couple of examples of the ground rules that we did talk about. We always ask the counsel for each party to sign by DocuSign confidentiality agreement that we use here in Boston. Just confirms the usual ground rules for mediation confidentiality. And we've actually amended that to have some specific provisions that are helpful to address the particular issues in the remote mediations. So we will arrange for that to occur. Another thing we'll probably talk about in terms of ground rules is how the parties want to handle the joint introductory session. Do they want to have presentations by counsel, or would they prefer to go directly to the breakout sessions? In terms of substantive preparation, one of the most important things in my mind that I try and do is have a private call with each attorney, or each attorney for each party in advance of the mediation, usually after the test session, so that I can better understand the parties' objectives in the mediation and their perception of what the barriers to settlement might be. I find that that's really important. I had a mediation a short while ago in which there were 5 parties involved. And by virtue of the knowledge that I gained in those private conversations, I was able to get people working together to start a productive negotiation fairly efficiently. If I were just confronting everybody for the first time in the mediation, you know, people be sitting around for possibly hours waiting to hear from me while I'm trying to figure out how the various parts of this 5-party mediation fit together. So that advance work is very important in this process. Now, I'll admit, when I was nervous when I conducted my first video conference mediation, and I really had some doubts as to whether it would be as effective as the more traditional in-person mediations that I'm more accustomed to. And I'm happy to say that based on my experience so far, as long as you've done the necessary preparation, I think the video conference mediation can be just as efficient as an in-person mediation. And I think the likelihood of success is just the same. So those are my remarks, Kristen. I'm going to pass it back to you.
Okay, thank you so much, Judge Ryan. So next up, we'd like to hear from Judge Neal on how to effectively manage the look and feel of a mediation.
Thank you, Kristen. We've all spent countless hours in conference rooms over the many years, some of us at least have been practicing, and we're used to face-to-face meetings. Until recently, at least, we've spent much less time together virtually on Zoom. And you'll have noticed if you've been on Zoom that people's appearances on that screen vary widely. Some people are very close, some are far away, some are well lit, some are not so well lit. And people understand that most of us are at home and the conditions are not optimal. But even so, it's important to be aware of some differences in the look and feel of video conferences versus or video mediations versus in-person mediations. Differences that arise from appearing as a static image, in part from appearing as a static image on the screen. That can be distracting and can keep participants from focusing on you and what you're saying. So I'm going to talk for the next few minutes about how attorneys, clients, and mediators can effectively manage those differences to minimize distractions and increase the likelihood of a successful mediation. I'm going to focus on 5 sources of those potential distractions and then on an easy way for you to address them. First, where are you in that Zoom rectangle? Are you too close? Are you too far? How much of you should show? If you're too far away, if you appear to be at the far end of a conference table, for example, you will almost literally disappear, both in presence and in voice, and that's not a good place to be. If you're too close, if your face is filling the screen, it gives the impression of invading personal space of the people who are looking at you on that screen. For most of us, we spend a lifetime of watching TV news anchors, and we have a sense of what the right distance is and how much of the person should be on the image. And generally speaking, I think that's the upper body and a sense that the person is a few feet away, perhaps across a table from us. That feels about right. The second potential distraction is, where is the camera? If your camera is below your face pointing up, the viewer is looking up at your face, which is not necessarily the best angle, and probably at your ceiling. That can be distracting. And if you have a laptop that you can put on some books or otherwise have a camera that you can raise to eye level, that's much more optimal. Third potential distraction comes from lighting. Daylight, ambient light may be the best and easiest, at least if it's not coming from behind you. If it's not available or it's at night, probably the easiest and best way to light yourself is to have two lamps, one on either side in front of you facing you, or perhaps at an angle. But try to avoid light sources that come from below your face, behind your head, or from overhead, because those can create unwelcome shadows on your face that can tend to make you in extremes look like a horror film character, which none of us wants. Fourth potential distraction, what is in the background? Some of my colleagues on this webinar have screens behind them, a green screen, and that presents a nice sort of boring, non-distracting background that allows the viewer to focus on you. Others of us have the space in which we are actually sitting showing, and that's fine so long as it's not cluttered or distracting in a way. There are virtual backgrounds that are available on some of your devices that you can put up of various scenes. Those can be successful if your laptop or other device can handle it, but if not, you may have distractingly wavy or disappearing body parts, which again is not a good look and will distract the viewer from what you're saying. Finally, how are you interacting with the other participants on the screen? When I walk into a room in a face-to-face mediation and in a breakout room, for example, and deliver a message, I like to be able to observe the people in the room and how that message is received. Who raises their eyebrows, who looks at each other, what the body language is. And it's certainly different on a video mediation, but if you have the gallery view, which you're probably familiar with, you can have speaker view or gallery view, the gallery view is that sort of Hollywood Squares configuration where you can see everybody, at least as they are being visible at the same time. On the other hand, if you're having a conversation with one person and perhaps an extended conversation, there's a way to quote pin the video, and the mediator or moderator can show you how to do that. It's easy to do, but that keeps that image of that person in front of you, and it's really a face-to-face encounter. Interacting with other people on a video conference also raises the question of sort of who speaks next and the issue of people talking over each other. There can be a little delay in the audio, and that can create those problems. And you don't have the visual cues that you might have if you're in a conference room and you see the body language of someone who's about to speak up. If there's a small number of people on that video conference mediation, that is probably not such an issue. But if there are a large number of people, you will work out with the mediator ahead of time how to get recognized, either by raising your hand or there's a button that can be pushed to alert the mediator and others that you'd like to speak. There's an easy way to check how you appear before the mediation session begins, and that is to record yourself in a way that I'll describe for you. But I want to emphasize that mediation sessions are not recorded. That's part of the security that you're going to hear about later in this webinar. But in the privacy of your own home office and with a free Zoom account, which is very easy to get if you don't have it, you can create a meeting in which you are the only participant. And you can practice your voice, your background, your positioning, and then when you, and how generally the look and feel of you in that setting. And when you then end the meeting, leave that meeting, a recording will pop up in a box on your computer screen, and you click on that and you will see the recording of you, and you can see yourself as others see you, identify distractions, and in particular, you'll see things that you may not notice when you're in a meeting or on a Zoom meeting, talking with other people, and because you're focusing on other things. You're not necessarily focusing on how you're presenting. It's also important in that sort of check-in in the privacy of your own home office with no one else looking, to see where you are looking, where your eyes are looking, and to see if you want to be talking directly eye to eye to someone, where you need to look generally into the camera to do that. I guess the last thing I'll say is that it's important to keep in mind that some people don't want to be on video. We can work with whatever that your clients are comfortable with, whether it's audio only, whether it's by phone. We can arrange that. So that's important also to keep in mind. That's what I have to say about look and feel, and I'll turn it back to Kristen.
Thank you very much, Judge Neal. Before I move to the next session, I just want to mention that participants will likely see on the screen some polls. We might have a few polling questions, so please feel free to take a look at those and answer them as they appear. And again, we'll do more questions at the end of the session. So up next, I'd like to hear from Judge Nancy Holt, and she's going to talk to us about how to best advocate via video conference.
Sorry, I had myself muted. So today what I'd like to talk about is just to give you some suggestions of how you as the attorney can help contribute to the success of the mediation day, success being defined as hopefully getting the case settled. And probably out of the gate, the first thing I would like you to recognize and share with your client is that a video conference mediation has all the same features and tools that a live mediation does. You'll have the opportunity to submit a pre-mediation memorandum. You'll have an opportunity, as Judge Ryan touched on, to have that private conversation with the mediator where you might want to talk about whether or not you want to do an opening statement, what your relationship is with the other side, opposing counsel, your own client, are there issues, are there concerns, all the things that you would normally talk about. You're still going to do that. At the mediation, there'll be the opportunity for a joint session. If appropriate, opening statements, there'll the usual caucuses, private caucuses. You'll have a room with your client or clients virtually, but you'll be in a room alone with your client with total privacy. And then the mediator will come in and out of your session in your private caucus room. So everything is the same. And that's an important thing to start with when you are talking to your client about whether or not they want to consider a video conference mediation. And I guess as Yogi Berra would have said, it's the same but different. And so that's video conference Zoom mediation. Now, the other thing I want you to be thinking about when you're video conference mediation and whether or not this makes sense for your client's cases, is that mediation success fundamentally requires engagement and a commitment to compromise to reach that settlement. So how do we get there? Well, what we need trust. And the way we get trust is to build confidence. Confidence in the process, confidence in you, the attorney, and confidence in the mediator. So how can you help with that? Well, for starters, you can help a lot with confidence in the process by helping your client get answers to all their questions, but the two that really jump out that we hear the most and are the most concerning out of the gate for all of our clients is, number one, is it safe and secure? And number two, does it work? So safe and secure, you're going to hear a lot about that today. There is a lot of material on the JAMS website, and in that pre-test session that Judge Ryan talked about, there'll be ample opportunity to get more questions answered on that score. But it's not just those questions, because your client needs to feel comfortable and familiar with the surroundings. And that is, again, why that pre-test session is helpful for your client to kind of get their sea legs. And if they have concerns, questions, they can be mundane, they can be substantive, but it's a great opportunity. And that helps give your client confidence in the process, because just by starting that conversation and having that conversation, you're already helping to build that confidence. Your clients are not just going to be concerned, as it said, they're going to be concerned about, will this work from home? All of us, whether you're a stay-at-home mom or you're a CEO of a Fortune 500 company, right now, if you're on a Zoom mediation, you're probably sitting in your living room, in your kitchen, and you've got, maybe kids running in and out of the room. They're doing remote learning and they shout to you, they want lunch, or the dog's barking, or some Amazon package comes and the doorbell rings. We all have these things happening. And so we need to have these conversations. And you as an attorney, can assure your client, as we try to do at JAMS, when we do our video conference mediation, is we are super flexible. And that's another thing that Judge Judge Neal had touched on. However it works for you, that's what we want to do. So that all helps, and that's how you can help build that confidence in the process. Building confidence in you, that's important for me as a mediator, is for your client to feel that you know what you're doing. And the good news on that is, one is Judge Neal has given you some really helpful tips just on kind of the optics. And it's not about an ego thing, but rather it's important for your client to feel that when you are going into mediation on their behalf, that you have that professional, sharp appearance that you would normally have if you walked into the conference room at JAMS. And the other thing about that is it gives clients a feeling in your room, as well as the other side, that you take their case seriously. Because we all talk about people wanting that day in court. People feel strongly about their cases, and they want to know that you take their case seriously. And let's face it, they're not going to feel that their case is all that important if they look at the gallery view and everyone's sitting there in sweatpants and it's messy lighting and camera angles and all that. So what Judge Neal talked about is very important. And as far as you looking and appearing competent and confident with your client, we have you covered on the technical piece. You know, there are webinars and articles popping up. Let's face it, left and right, all over the place about Zooms and Zoom webinars and video conferencing mediations, and lawyers are exhorted to just practice, practice, practice. Well, the good news is, we have you covered, because we have these full-time case moderators dedicated to your case. So you just have to click a link. If you want to upload a video, share an exhibit, get a document looked at, we can help you with all that. So we can help you project and instill that confidence. Confidence in the mediator. So how do you help with that? Well, one is presumably you're going to try to pick a mediator that makes sense for your case, your client's case, and for your client. And here's one area that actually is a plus for Zoom as opposed to live mediations. So here's how it usually works. The morning of mediation, I come walking in and you introduce me to, this is the CEO and the CFO and the COO, or this is the HR person. Here's the plaintiff's mother, father, sister, brother. And I get an onslaught of faces. They've never met me. I don't know who they are, and I need to spend a fair amount of time building that trust with rapport building. However, with Zoom, normally I've never had someone bring their client into my office and say, can we meet you before we decide to pick you? This is just easy to do now. So you may have a case where you might say, Judge, my client is somewhat interested. They're almost at the altar, but they're just still a little hinky about this whole thing. And anyway, we could just kind of get to talk, because then you have that opportunity to help your client build some trust and confidence in the mediator, because before you even start, there's been a little ice breaking, whether it be in the pre-test session or, again, even when you're selecting a mediator, you have a chance to have that actual, conversation, so your client can have the feeling, is this someone I'm going to be able to work with or not? The next thing I want to touch on, and this is a big one, engagement. Now, again, I walk into mediation rooms, and some of you have your clients sitting there and they look like hostages. It's clear that they have been told by you, don't talk, don't say anything, don't give anything away to the mediator. And when they have their conversations about what they're hearing, they wait until I'm out of the room. And that's a tactical decision. I get that. But you now have clients that are going to be sitting in some room away from you physically. And in order for your client to be engaged, they need to be engaged. Your clients, when I hear the clients talk about their cases, whether it be a plaintiff or a defendant, no matter how plain old fashioned or sophisticated the party is, they feel very strongly about their case. They're passionate about their case. And I want your people, I want your clients, and I want you as attorneys to come into the mediation and be passionate about the project at hand, which is getting the case settled. I want everyone on team settlement. And to be on team settlement, you have to be engaged. And if your client is sitting in their den with an Afghan on their lap and their dog at their feet, just watching you joust with the other side through the mediator for 8 hours, they're not committed to the process. They're not engaged. So even though this may go a little bit against some of your grain, is you need, with the mediator, to get your client engaged in the process. And that means let them talk a little bit more than you might otherwise do. Let them ask some questions. Let them make some comments. I know that attorneys basically are in the driver's seat during mediations, but sometimes, especially in this context, I would suggest a good thing to bear in mind is maybe get out of the driver's seat and let someone else take a at the wheel that will keep them engaged, and they'll want to get the case settled. So I know that I've been talking too long, so I'm going to stop now. I think we should have time for questions during this program. And also, I think I speak for all of us. I love talking about this stuff. I have plenty more I would love to say. So if anyone wants to reach out, please always feel free, call me, email me, and I'd love to get on a phone or a Zoom conference with you and or your client at any time. So Kristen, back to you.
Thank you so much. Yes, and we definitely will have time for questions at the end. But up next, we're going to go to Deirdre and Siobhan to talk to us about training.
Great. Thank you, Kristen. And as Judge Ryan, Judge Neal, and Judge Holst pointed out, there are definitely benefits to and successful ways to use the video conference platform to settle mediations remotely. Just a little bit on our experience thus far. Definitely, we've been doing this for years. We've seen a lot of activity recently. As folks explore this approach to keeping their mediations on track and keeping things on schedule. So just in the past 3 weeks alone, JAMS has scheduled more than 500 matters for online processes. This is across the country, across practice areas. It includes things like class actions, a large construction defect case with multiple parties. And in fact, one panelist did a case recently where there were 30 different breakout rooms, and the panelist was navigating back and forth between those breakout rooms to settle the case. Just to underscore a few of the points as far as what you can expect from virtual processes, generally virtual mediation. Definitely the environment is different. What's interesting is you can really do just about anything in a virtual setting that you could do in a live session. So you can meet alone with your client in a confidential space. You can meet with the mediator and your client in a confidential space. You can meet with opposing counsel and the mediator in a confidential space. And as far as what you can expect in a virtual process with JAMS, and this is really where the training piece comes in, what you can expect is a well-supported program to ensure that the results of your session meet our collective high standards, and to ensure that you can focus on what you need to focus on, which is your client and the case, and trying to get this resolved through mediation. So how do we ensure that? One way we ensure that is with robust training for all of the JAMS panelists so that they can do all those things that we've talked about. They can put people into breakout rooms. They can pull out counsel and meet with them separately and then get them back to where they need to be. So JAMS panelists have really just spent many hours to make sure that when you get to that mediation table, you are able to focus on the mediation, and the technology is actually a help rather than a hindrance. And just finally, as far as what you can expect kind of leading up to your process, I heard the word flexibility, and I think that's really important to underscore, because even though everybody is using the same platform, one size does not fit all. And what your process will look like pre-session and during the session is going to be determined by the needs of your client, by the needs of, what the case requires. So, as Judge Ryan mentioned, having a pre-session tech check, that's something that's available to everybody. And having the client involved, if you think my client is really reticent about using this technology, then a 15-minute tech check just to get oriented in Zoom can really make a huge difference with how they feel when they actually get to the mediation table. Also, just learning information about the case substantively and also kind of procedurally. What will we need to do when we get to that Zoom mediation? Will documents need to be shared? Okay, we're going to be ready to do that. What are your concerns? What do you think you will need for your case, and how do we make that happen? And with that said, I'm just going to move it over to Siobhan so she can talk a little bit more about our associates program and what to expect, leading up to and on the day of the mediation.
Thank you, Deidre. Hello, I'm Siobhan Applewhite, as stated. I just wanted to quickly go over the JAMS moderator program. So this program was developed in conjunction with the Zoom platform that we have adopted into our mediation process. The JAMS Associate Moderator is an especially trained JAMS Associate that has undergone training with Zoom and the technologies of Zoom, the platforms of Zoom, because there are various ones. And they are there assigned to your case at the beginning of your session. As soon as your session is confirmed, your JAMS moderator will reach out to the parties to schedule that test session you've heard so much about. They'll also be in contact with your mediator or your arbitrator. They are there at the start of your session. They help you with your technology, your equipment. They welcome you to the session. They help your clients. They're basically there to offer a white glove service that only JAMS can do. We take time to train these associates. We give them basic training, advanced training. We're in constant communication with them, and they're part of a larger team. With that said, the moderator is there also during your session because things, as we know, do happen as these sessions are ongoing. But the moderator program is very special to JAMS. It is something that we have developed throughout the course of this process, and it is one that we can be proud of because the moderators have really excelled all of your sessions that have been scheduled, that have completed, that have settled, and they have been very much a part of the process just as much as your mediator or your arbitrator. And we are just proud to say that this is something that we offer to each and every session that has been scheduled with us. And we do take all the security measures that go along with those sessions and scheduling very serious. And I will then turn this over to Rich, who will talk to you about the security measures that go along with your confirmed session with JAMS and your scheduled moderator. Rich, thank you, everybody.
Great. Thank you. Well, one of the things that you may not know is many people in this session, even if we speak saying all of our R's, are from Massachusetts. I was born in Lowell, so maybe in order to go fast, I'm going to switch into Lowell talk. So a lot of people are concerned about security, but I don't think you really need to be that concerned about security. I'm one of the senior managers of JAMS, and so I get to see a lot of data. We're scratching actually at close to 1,000 set cases, and I'm going to knock on wood now. We have not had anything approaching a disaster. But that said, I do want to share my screen and talk with you a little bit about some of the security issues, and I'm going to go very quick. And so ready? I'm going to go into my Massachusetts accent now because the first image you're going to see. All right. There we go. Right there in Cambridge on Mass Ave. I was a member of the Mass Bar. And so, you know, this facility here is one of the most secure facilities in all of Massachusetts, but you can see it's a rage warehouse. I approve. All right, so now let's talk about what's happening with class actions. There was a class action against Zoom, and I'm still talking Lowell here. I might do this for a minute. There was a class action against Zoom because they had the lack of common sense to get into bed with Facebook, and they were selling data to Facebook. However, the Zoom protocols have completely changed as of about 3 weeks ago. So if you have a Zoom account now, you don't have to worry about anything associated with that class action. They are no longer selling data. All right, now what's next? Well, people are worried about somebody getting a hold of videos that you recorded on Zoom and maybe stealing those videos. And so you see this little button here, the record button. That button is disabled in all JAMS mediations and arbitrations. And what we like to say is nobody can steal a video that never existed in the first place. So the class action is not an issue. The stealing of videos is not an issue based on the way we set up our settings. You may be worried about this thing called Zoom bombing, that an uninvited person is going to come and show you something that you can't unsee or unhear. Not a worry, because if you use a function that we always use in every case, which is the waiting room, then basically our neutrals, the judges that we've already heard from this morning, would give to their case manager a service list saying who's going to be there and who's going to be in what room. And then somebody from JAMS would escort each individual out of the waiting room and into their room. So given that nobody can sneak into that room who's not on the service list, and nobody's going to get from that room into the general meeting unless the mediator has specifically authorized that person, then no Zoom bombing. Now you can also see we have this wonderful little security shield, and if you tap as the host, the security shield, you can lock the meeting to prevent anybody else from coming in. You can allow participants or not to share their screen, to chat, or rename themselves. The breakout rooms as well are, you know, if you look over here and you see the breakout rooms are completely secure. As the mediator, I can't hear what's going on in a breakout room. I can't even send a chat to you when you are in a breakout room. It is that secure. In fact, some of the security features that Zoom has put into place in the last couple of weeks are almost inconveniently secure. We would love as a mediator to be able to send you a chat to say we're coming in, but Zoom has made an absolute complete brick wall that won't allow us to get in. In order to just be quick on time, I'm going to say you can do this, you should do this, and we are ready, willing, and able to help in any way that we can for you to be able to do this. So with that, I'm going to stop my screen share, and I'll go back to a non-New England accent. Thank you.
Well, thank you so much, Rich. That was the first time I had heard that accent from you. You did pretty good there. This is all really great information. What I'd like to end our program with before we go into questions is just speak with a few of our panelists on any of their last minute tips and tricks, things that maybe you didn't get to in your session, or things that you can really suggest to the parties, to council on how to make this a successful process. So Judge Ryan, do you have anything else to add on tips and tricks to give to our participants today?
Hello, can you hear me now? I'm sorry, it took me a second to find the unmute. I guess I'd just say two things very briefly. One is that I talked to the parties about the need to really be committed to the process. When you're in a video conference, there's one disadvantage. If the folks are in the office with me and somebody gets upset, I can get between them and the elevator and keep them from leaving. Whereas when it's a video conference, all they need to do is press a button and I've lost them. And so I really do talk to people about, you know, staying committed, staying involved in the process. That's the one thing I wanted to say. The second thing I wanted to do is give a shout out to Rich and Deirdre and Siobhan for, I'm an old dog and I've learned some new tricks, and it's basically because they've made that happen. In fact, later today, I'll be joining a best practices video conference where neutrals from all over the country, California, Chicago, Washington, D.C., will be sharing their experiences in mediations that they've done, what worked, what didn't work. And I'll know more by tonight than I know right now. And I want to thank them for making that possible. Thanks.
That's great. And I think that's a really great point, is that we're all learning every day. You know, there's endless amounts of knowledge. So that's something to keep in mind, is that it's a learning process and we're doing it together. So that's great. Up next, Judge Neal, do you have anything else to add to our participants today?
Just a thought about the difference between looking at a screen for 4 or 6 or 8 or 10 or 12 hours and being able to be in a conference room and go get coffee and go get a snack, and it's a different, you're on a different schedule, and I think it's useful for the mediator to work out with counsel and the parties ahead of time, building in breaks so that everybody doesn't feel that they need to be married to the screen for that entire time, and also maybe even in a an in-person mediation, I get lunch on the fly, and the parties, that we keep working through lunch. I think as we develop experience with doing these kinds of mediations, we will learn maybe we need to give everybody a break, go, take 20 minutes, go have a sandwich, go answer your email or whatever. But those kinds of almost ergonomic differences between being in a mediation on the screen as opposed to being able to move around in a JAMS facility are something that we just need to pay attention to, and sort of we'll figure that out.
That's great. Thank you so much. Judge Holtz, any last comments from you?
Yes, well, everyone's covered so much, and I think really the touchstone seem to be that what I'm hearing and what I've experienced. It's preparation, commitment, and flexibility. And I think those are the things I would really like to have you all think as takeaways. And one thing I can tell, as I see questions coming in, I started and I didn't get a chance to loop back to the question of assuring your clients, does it work? I can't tell what's going on nationally as I talk to my colleagues, but I think anecdotally, the sense that we're getting is the cases are settling at as high, if not a higher rate as they have been. And I'll tell you this, I've done Zoom mediations over the last few years. I did a very contentious business dispute where the parties were in Hawaii, New York, and Boston, and it settled. I did a very highly, highly emotional employment case where there was a plaintiff in London, and that case settled. I did another one, believe it or not, where the parties were in Istanbul, and we were able to get that settled as well. So that it does work, and again, those are the big questions that your clients have. And if you come and if you're prepared and you're committed and you're flexible, and part of flexibility, look, we've got to have some humor here, because the fact is, I don't think I've been on a single webinar, even a conference call, Zoom conference call, where one of us hasn't forgotten to unmute ourselves, or someone has had, all of a sudden, a kid comes in and they want to know when is lunch. These things happen. People get kicked off a call. We have to approach this with a collective sense of basically common sense and good humor. And the bottom line is, if you want to keep your cases moving, we can get your case resolved through mediation at JAMS. That's it.
Great. Thank you so much. So now we have about a little over 10 minutes left. So I'd like to go questions and answers. You can use that Q&A function at the bottom. People are already doing that. So the first question we have is, do you have people agree to using Zoom software before the meeting? Has any disclaimer language been created? Siobhan, if you could take that question for us.
Sure. Hi, everyone. So you do have to agree to use Zoom when you actually decide to download their platform onto your computer, but you can also join via the web, which is joining by your browser. And then you don't have to agree. You're only simply joining the meeting. So it does not require you to affect your computer or any of your equipment by downloading the Zoom client. And then we do have a disclaimer that will go out in your confirmed session, and it is regarding the security of the information that we're sending to you. And it is just simply put by our legal team, please do not share your meeting link or the password on any social media platforms or with anyone that is not approved on your service list for your confirmed session. Thanks, everybody.
Kristen, can I just jump in and just add the technological particulars are above my pay grade, but I know that one of the things that, there had been some rumblings is some attorneys had expressed concern and worry about HIPAA concerns. And my understanding, and the particulars again are on the JAMS website in the frequently asked questions section, my understanding, and Rich or Siobhan, you might be able to elaborate, but my understanding is those HIPAA concerns have been buttoned up and that's no longer a problem. And also we use Zoom, but we're all schooled, our moderators are schooled obviously in all the other platforms, things like WebEx, and there are a number of others as well.
Great, yep, and that's correct. We now have the Zoom HIPAA compliant platform that we use for all of our cases. And if there's a different platform that the parties want to use, JAMS is more than happy to work with the parties to make sure that can get that working for you. So the next question is going to go to Judge Neal. The question is, how long do any of the panelists suggest that video conference sessions with the parties together or with each party individual should go on for?
Sure, I'm interested in my colleagues' answer to this question, but my sense is that it remains important to have an initial joint session brief, but with everyone together after everyone's been brought into that main room from the waiting room, so that I can, maybe even more important, I can, as the mediator, you can set a tone for the day, try to build that commitment that my colleagues have talked about to the process, recognize and acknowledge some of the inevitable interruptions and distractions that will happen because most or all of us are in our home, somewhere in our homes. And if although my view of the utility of opening statements has been declining steadily since I started this 11 years ago or 9 years ago, if it makes sense for attorneys to make an opening statement, that would be the time to do it, or give a brief overview of the case. That, by the way, is something, and I'm sure I and my colleagues talk with counsel about ahead of time, just so people know what to expect. But obviously, the most of the time during the mediation session is going to be the mediator meeting with the parties and counsel in their respective breakout rooms. So that's my sense.
Great. There was a question here about Zoom ADR disclosure. Any information about, we obviously don't work for Zoom, so any information about Zoom and their security you can find on their website. You can also visit our JAMS website, jamsadr.com, and we have a virtual mediation page where it has a security FAQs and a wealth of other information. So those are 2 resources that you might want to check out. The next question we have is, how would you suggest an agreement be memorialized in writing or otherwise at the end of a successful mediation? So Judge Ryan, would you like to answer that one for us?
Sure, that's actually one of the issues that I'll often raise during the test session with attorneys, because there are many options available. JAMS has DocuSign, which is used you can get electronic signatures on a formal agreement. But I have done it much less formally in some cases, if that's appropriate. I have had parties exchange emails with confirming the terms and then a confirmation email. I know that that's an enforceable agreement if the parties do that. We've had parties photograph their signatures on their smartphone and send those. It's an issue that needs to be addressed, and it depends on the type of case you have and the complexity of the agreement that you're going to be seeking to reach. If it's going to be a complex matter, I often suggest to counsel that before the mediation, they do some drafting and some exchanging of possible language that they would want to use. So there are many options.
Great. So the next question we have is, how do you handle the fact that trials aren't going to happen for some time? A trial is most often the leverage to get the case resolved. I don't know if maybe one of our panelists want to take that question. Maybe Judge Helps, do you have any comments to add there? Great.
Well, I think, there's obviously no doubt that the looming trial date, when we were, those of us on this, the 3 of us here, we know that as judges, ready till reached, attorneys are all ready to go to trial, and then the best settlement tool is a firm impending trial date. So that's definitely, that's a club that's no longer there. But I think that there are other incentives that remain to settle cases, which is the economic downturn. So, there are companies that may feel parties that may feel from a plaintiff perspective that this may be a time where you want to try to get your case resolved because you need the cash in hand now. You don't want to wait for a year or 2 when you get a trial date again. Similarly, on the defense side, they may not want to spend the money, but at the same time, maybe this is an opportunity to get a case off the books and get some value. I mean, there are all kinds of different permutations, and the bottom line is there's no one size fits all. But if your client wants to resolve the case, the platform of virtual mediation should not be the impediment. And whether it was, look, if someone snaps a finger and we're all back to being live again in person, those same issues are going to be there, and it's simply going to be, is it in your client's best interest to resolve this case now versus later? And the trial date, it is, the overused expression, it is what it is, but there are other reasons why the parties should be incentivized to move forward.
Great. The next question is, do you find online mediations more draining than in the flesh mediations? Judge Ryan, do you want to give us a comment on that?
It's sort of hard to compare. There are certainly different challenges. I find them both to be draining, frankly, and but I find the ability to move around in a live mediation gives you a release that sometimes you don't get when you're stuck at the screen for as long as you are. But it's manageable. It is, and I haven't tried the arbitration process yet, so I can't really compare that.
Great. Okay, Rich, did you have anything you wanted to add something there?
I just have to leave. So
okay.
I want to thank you all and say goodbye. Thanks.
Thank you so much, Rich. Okay, so the next question is, when and how do you send the pre-mediation agreement to mediate? And Siobhan is going to take that question for us.
Hi, yes. I will say that your case manager, who directly works with your neutral to confirm your matter, will send that mediation agreement to all the parties once the session is confirmed, and they will be working diligently up until the time your Zoom session starts to get those signatures back. And that usually, we usually don't experience any problems with that because everyone is using DocuSign, which is an electronic signature platform, to sign their agreement and return it to the case manager. Thank you, Kristen.
Great. I'm actually going to pass the next two questions over to you too quickly, Siobhan.
Okay.
Is, if an attorney is in one physical location and her client is in another, how do they communicate with each other privately within a breakout room?
Great question. That is utilizing the breakout room feature. So basically, both of your screens, both of your video connections will be placed into a private breakout room where you can speak freely or chat freely with each other. And that is with the mediator, which will join your session if needed, or without. So it basically transports you and your attorney, the client and the attorney, to a separate room for a private conversation.
Kristen?
Okay.
Just on that point, when in a live mediation, I knock when I'm ready to come into that room, and because I don't want to just walk in. And one thing that we mediators can do in a virtual mediation is send a text to the attorney that we're on our way over, so that we're not just walking in on a conversation and hearing things that the parties don't want us to hear.
That's a really great point. There's then a question about virtual backgrounds. I think you'll see on here we kind of have a mix. So Judge Holtz has a virtual background up. Deirdre's in front of a green screen. Yeah. The rest of us just have our background.
I have a 12-year-old. Therefore, I have a green screen at home, and so I can bring you to here. I can bring you to New York. For fans of Parks and Recreation, this is Ron Swanson's office. So anyway, there's that.
That's great. Yeah. So, and my internet connection is not as strong as maybe I'd like it to be. So I don't use a green screen. I don't use a virtual background because it doesn't really look great on my background. So that's something that you can play around with. Again, as Judge Neal talked about, if you download, if you go in and get the free Zoom account, that's something you can mess around with to see what it actually looks like. Could be on the beach like Judge Neal.
Right. And Kristen, I'll just say my computer does not have the capacity to load a virtual background. So my green screen is actually a physical green screen. I jumped on Amazon a few weeks ago and ordered this, set it up in 15 minutes, and at least it's, kind of just a solid color behind me.
Great. So there's another question. It says, directed more to client attendees. Do you mute other attendees when a party delivers an opening statement, or simply count on the parties to act civil in this manner? I'll just comment on this quickly. So there's a host, either the moderator or the neutral will be the host of the session, and they have the ability to mute individuals. So if somebody's giving an opening session, they can mute everyone. that's also something that the mediators are addressing at the beginning of the sessions too, to when to mute yourself, when to not mute yourself. So it can be a preference thing, case by case. But so for instance, in this session, we're all muting ourselves when we're not speaking and then unmuting when we want to speak. But as the host, you do have the ability to mute people just to make sure you can control the conversation. The next question is, do you schedule a lunch break for everyone at the same time, or do you stagger to keep working? Let's see. Judge Ryan, in your last mediation, did you schedule lunch breaks, or how did that go?
Yes, yes, I do that. That's another issue we talk about during the test session and reach an agreement on. I definitely, in cases where I have a full day, we're going to spend the entire day, I do try and program at least a half hour in, because I ask the parties to stay connected throughout the mediation. And I find it's helpful for them to know that 12:30 to 1, we're going to be free. We don't have to be near the computer, etc. So I have done that and found it to be useful, and found it not at all to be contrary to keeping momentum. I think it hasn't been a problem in any of the cases that I've worked on so far.
Oh, Kristen, if I can just jump in, what I've done, actually I have one tomorrow, and I asked the attorneys, I said, do you want to, because I usually, when it's live, I power through and everyone just grabs grabs their sandwich in the kitchen, and like Judge Neal referenced, we usually inhale a sandwich somewhere along the way, as we're mediating. And I asked the parties, and so for example, tomorrow I asked them, what do they want? Do they want to, do they want a formal lunch or not? They said no, let's kind of wait and see what happens. I do think a formal lunch break is good, but also what I've done is I don't expect them to literally be in front of their laptop for the entire time. I just say, look, if you want to just turn, you can stop your video, so now your name is there, so no one sees you, and then you can go about your business, do something else. And if you even move away from your laptop, just keep your cell phone. So if you go out to the kitchen to grab yourself a sandwich, or go up and check on the kids, or do it, walk the dog, or whatever out front, you have your cell phone, and I'll ping you, I'll text you and say, okay, we're ready for you in your room, or we have a new offer, we have a new demand, or what have you. So there's a little bit less, you're not quite tethered to the laptop, and which is why we all have to work a little bit more actively to make sure that the clients stay engaged in the process and don't feel like they're just kind of spinning out of orbit somewhere. But it seems to be working. Again, our cases are settling. We're getting it done, and that's thanks to the attorneys who come prepared and ready to get the case resolved with us.
Great. So we just, I know we're a little bit over the time. So there's a few last questions here. One question is, how do you knock? I think Judge Ryan had just mentioned that before, that he would text the parties to let them know that he was coming into the room. Siobhan, did you have anything else to add there?
Just technically inside of Zoom, there's about a couple seconds delay when someone enters a breakout room. So what we've been instructing neutrals to do is just simply turn off their video and leave their audio on when they virtually enter the room. That way they can announce themselves and ask the parties, are you ready for me? A nice way to knock.
Yep, that's great. There was a question about lighting. I'll just direct you, so you don't necessarily want light behind you, but if you go on zoom.com, they have tons of quick videos that are really helpful, just technical videos to help you, and you can sort by topic of basically anything that you want to know. So that's a really great resource if you're looking for some just quick technical assistance. So I'm trying to just make sure I think we've answered all of the questions. So I just want to give a huge thank you to all of our panelists for all that amazing information, all of the attendees. This was, those were great questions. I really appreciate all of you getting on the line to talk to it with us today. So again, I'm Kristen Schuck. I'm the business manager in the Boston office. Feel free to email me, give me a call if you have any questions about Zoom or scheduling. We're here for you, and we're more than happy to help you in any way that we can. So thank you, and hopefully we'll be seeing some of you soon, virtually or not.